We're on the record in the matter of the city of Wyandotte versus Amber Cattrall, 222243. Oh, was that Ms. Cattrall that I put out into that went out to the lobby?
I believe she was with another gentleman, Your Honor.
Okay, Dave, can you grab Ms. Cattrall, please, from the lobby?
She's present now, Your Honor.
All right, and so, counsel, your appearance, please.
Your Honor, good morning. Richard T. Serrano, P33828. Today, Your Honor, I appear at DC Counsel on behalf and with Ms. Cattrall appears to my right. This being the date time set for a show cause hearing. Please state your name, ma'am.
Amber Cattrall.
All right, thank you. And yes, today is the date scheduled for a show cause that shows that on January 18th of 23, your client was sentenced to probation and $1,500 in fines and costs. And Allie, what does it show the current balance is?
$1,250.
All right, and there hasn't been any payments made since, when was the last payment made, Allie? Okay.
Well, the civil infraction part of it, proof and check for the 170.
I can't hear that. What? Ma'am, I didn't ask you to speak yet. I'm asking my staff member. So just please wait just one moment.
That was my fault.
What was that, Allie?
There's no proof of insurance. That's where it's the case.
That's with this case?
Yeah, the 23433.
Okay, and so is that including the $1,350 balance or is that in addition to the $1,350? Okay. So the total balance is $1,525. Okay. All right. And so counsel?
Your Honor, my client, quite frankly, does not remember taking the plea. She told me. I showed her the evidence of it. She wants to hire an appellate lawyer now to withdraw her plea. That's what she wants to do. Is that correct, ma'am?
Yes.
Speak up.
Yes, sir, it is.
Well, ma'am, you even completed probation. So I'm not, and I don't believe that you're within the time frame for an appellate attorney. But this court sentenced you, ma'am, to the fail to stop or identify after a property damage accident and driving a license expired back in October of 22. And there was a plea, I'm sorry, no insurance as well. There was a plea down to a fail to report and no proof of insurance. And you even completed all of your 12 months of probation. You don't remember any of that.
I know we were supposed to come back to court for it and get the discovery back. And however this plea ended up taking that day, however it happened, I specifically don't remember doing or starting any of this probation for it, hence no payments that were made. The man that was supposed to show up on a zero restitution, the case was supposed to be dismissed afterwards. I don't know any of this. I got this in the mail. I just served a year in county, in Macomb County. If anything got flipped for outstanding, it would have came up before I was released. None of this.
That's not accurate, ma'am. We didn't issue a warrant because you didn't pay, so that wouldn't have been picked up.
Right.
If there was a warrant, that would have been picked up.
I would still like to progress with this if I can, however, which way I can.
Progress with what?
Because we have on film, we went and we interviewed this man where he made there was no police on. The police came up to my house with a ticket and said, were you in a car accident? They got his license plate. I was not driving. We didn't have insurance. I didn't have my license at the time, and I was not driving a vehicle. Now, I do, in fact, know who drove the vehicle. Here nor there, it was not me. And they said, because I was a lady, this is my boyfriend, his truck. They said, because you're the one woman. I said, where you drive this vehicle? And they gave me the ticket in my name. We came to court. He said he wanted zero restitution. He wasn't progressing with anything. And then there was a whole thing written up for probation. And I said, well, it should have been dropped there because he said I wasn't the person driving and we have him on film and we went and interviewed him to his house. All he had was a Zoom camera with a license plate of the vehicle leaving. Cops didn't come over to the house till 2 days later. So 2 weeks later. So I wasn't stopped with the police. I wasn't flipped to get any of my license or registration on the spot. Just because my name and I didn't have it didn't mean that I was driving.
Let the court.
Well, let me just indicate this, that you were here on November 22nd and you had an attorney representing you.
Your Honor, who was that attorney? I couldn't read the writing.
Wait. Well, it shows as though it was maybe Mr. Shemke, but that doesn't look like Mr. Shemke's writing. It could have even been your client's signature. I don't know. Who does it say was the attorney on November 22nd, Allie?
Second was Corey Westmore.
Oh, okay, Mr. Westmoreland. And so it indicates that it was reduced to fail to report an accident, no proof of insurance. The other matters were dismissed and responsible for any restitution, if any, to the vehicle. And then you went over to probation and you spoke with probation. They gave you a copy of your probation order, and there weren't even any probation violations, ma'am. So in some of and here are the conditions of your probation order. You had random testing, restitution was $0, community service, seek and maintain employment, better driver's class, obtain valid license, set up a payment plan with probation by February 17th of 23. And you didn't set up a payment plan, but somehow, well, I don't know if you set up a payment plan or not, but somehow.
Just the payment plan. I can work with the payment.
But somehow it wasn't brought forth for a probation violation. So, how much can you pay on your $1,525, ma'am?
Your Honor, before that is answered, obviously, if she's acknowledging that she now owes money, you're not going to be able to appeal it if you're going to be making payments. So which is
Well,
it?
she told me that the time allotted is yes. If I still can't come to court for this, I'm going to come to court for this.
Your Honor,
I'll get the discovery back.
wait. Your Honor, could she have an short adjournment to at least speak to a private attorney about maybe leave to appeal matter? And then we'll come back, and if she wants to pursue that aspect, then she can. If not, she will make a payment program. Is that adequate, ma'am?
Yeah. I mean, there's no way out of it, but I'd rather just.
Okay, wait, don't say anything else.
Back.
We'll adjourn this to December 10th. Wait, are you here that day, counsel? You are here. Oh, no, that's November. Hold on.
I'm sorry, I don't have my December calendar handy, Your Honor.
You are here December 10th
Yeah.
at 9 a.m.
Okay.
Okay.
I need some information.
No court will order a $5,000 personal bond. Ma'am, when you received the letters before your show cause hearing, did you contact the court?
Before when?
Before?
This is the first information I had was for the court date.
Nope. We sent out 2 letters. Before the show cause, we sent out 2 letters. So you apparently received the show cause because you're here.
Yeah.
But you're
I'm
saying,
no longer at that address, so any.
but you're saying that you
any
didn't
message
receive,
I got.
excuse me,
Letter.
but you're saying that you didn't receive the letters. So you received the show cause notice, but you didn't receive the letters.
I don't believe so, no. Well, I'm not at that address anyway, so I have to fix that computer.
You have to stop at the window and make that change.
Okay, December 10th, 8 a.m.
9 a.m.
Are we all set, Your Honor?
Well, no, we're not done.
Come back.
$5,000 personal bond. And you make sure you do not leave without stopping at the window to change your address, please.
Okay,
Have a good day.
thank you.
Thank you, Your Honor.
I have a sex.
You have a sentencing. Which sentencing do you have that's ready?
Up here, Mr. Frank,
Mr. Franklin,
who's
who's
Jeff.
giving the sign of the cross. Okay. Are you ready? I have Mr. Franklin. Are you ready, Mr. Franklin? And then Mr. Dabolsky, we can handle you.
I'm ready, or I can go out and deal with someone. I'm ready, Mr. Frank.
Okay, great. We'll do Mr. Franklin. All right, let's go on the record in the matter of the City of Wyandotte versus William Franklin, 251102 and 22379. Counsel, your appearance, please.
You're on gold for 30758 on behalf of Franklin. Please, Mr. Franklin, please unmute yourself and put your name on the list.
William Franklin, Your Honor.
Good morning. And so today's the date scheduled in this matter for sentencing on your client's plea to assaulting, resisting, obstructing an officer. The disorderly conduct was dismissed by way of resolution between counsel. And then there's a jail review on the 22 case. the court had originally sentenced your client to jail on August 20th of 24 after a probation violation. Well, one of many probation violations. The court suspended that jail. And then your client was ordered to participate in random testing. On February 1st, he tested positive for cocaine, failed to appear for testing February 4th and March 2nd. All of this was of 25. Ordered to attend fan meetings, but not yet submitted proof. And his last payment was 15 months ago. His balance was $1,975 on that one. And so, counsel, as to the sentencing, you have an opportunity to review the report and recommendation with your client.
As to the sentence, Your Honor, there are no additions, deletions, or corrections to be made. However, Your Honor, he is presently rated on County Jail. He was bonded 5,010% with an alcohol tether. There is a hearing on that matter scheduled for the 20th of November.
For tomorrow?
Yes.
On a felony matter?
On a felony matter, but not in this court, down in front of jury.
Okay.
Excuse me. Also, Your Honor, as to the sentencing, the recommendation is for costs and fines as well as incarceration. I've spoken to Mr. Franklin. It appears that Mr. Franklin, I've spoken to his mother, who's present in court today and has been present, I believe, on a number of occasions. Mr. Franklin was for a period of time living at home. Living away from home. He has subsequently returned, and once he is released, hopefully today or under other circumstances, rather than the incarceration as recommended, that he will be returning to his mother's home. He understands that all of his problems, or the majority of his problems, are self-inflicted due to alcohol. He has been in jail approximately 30 some odd days at this point in time. And his time of sobriety has really wakened him up, awake. Know that he has gone through other programs, but it's my belief, and he wants to make a statement as well, Your Honor, that he plans, hopefully at some point in time, to return to live back with his mother and his grandmother and have her act as she has been sober for, according to his self-reporting, 10 years. As a sobriety coach, as a sponsor. He has been taking classes in AA and going through the 12-step program while he's been incarcerated. And we're asking the court to take all of that into consideration. I do know that he does have a checkered past, to say the least. I believe he has finally a very young man. He does have some mental health.
Don't worry about me.
And though I'm asking you not to follow the recommendation, but to meld some sort of program he can continue to get the help he needs going with his alcoholism and proceed from there.
Okay. Just for clarification, the matter he's bound over to a circuit court on is out of this court.
That's correct, Sean.
Oh, but it was not out of.
I thought when you said tomorrow the 20th, I meant the hearing was not in this court.
Okay.
I apologize, Sean.
That's okay.
No,
And what's the bond violation hearing?
it's not my violation.
I thought you said there was a bond
No,
violation hearing.
it's a bond review. It's a DSU.
Oh, bond review.
Right.
Okay.
He had a calendar conference and he's done all of that.
Okay.
But it's not a bond violation.
Okay. Mr. Franklin, what is it you wanted the court to know?
I just want to know that I've been working the steps, and I take full, admittance to all my problems throughout the years. I definitely haven't had an easy way with alcohol. It's every time I drink it, every single time I drink it, something bad happens. And it's the only time that something bad happens with the law. Other than that, I'm an outstanding worker. I just have struggled with my mental health for a couple of years. I've been on my own for 6 years trying to do it without my family. And I think that I was missing a lot. I had several miscarriages throughout the years with an ex-girlfriend that kind of drew me to be really down on my luck with a lot of things and drinking out of depression. And I realized when I got in here, actually when I woke up in Wyandotte jail for the felony assault matter, that I had to take willingness, or I had to take admittance to that I have a problem with all of that. And I started doing the 12 steps. My grandma's at home, and I really want to get on the tether to even push me towards another step of, just staying on the right track with a little extra help. That I do admit that I have a problem. I haven't always done right by the court, and I know you guys are always just trying to look out for me. But, sometimes maybe I was just stubborn and I couldn't get it through my head that I wasn't, that I didn't have a problem, and I do. I definitely don't have any intention to drink. I have been working the steps, and I enjoyed working the steps on the tablet in here. That's really all I can do in here. Is try to be mindful of everything that I've done and take action on it. Whatever the court decides, I'm gonna try my best to remain sober and keep working those steps. My grandma's been sober for 10 years, and she just recently moved back, and I haven't lived with my family for 6 years. I've been on my own, and upon losing my house and almost my dog, I think I had to take a real look at myself and what my actions are causing my life to turn into shambles. That's all.
Okay, thank you, sir. Again, I can appreciate that you don't have any intention or desire to drink right now because you're currently in custody. I can see that, sir. And also you're going through your program. The concern the court has is when you're out of custody,
100%.
what steps are you going to use to maintain your recovery?
Continue. I asked that I be put on an alcohol tether and that I have the testing. And then I will be going through I know a couple of meetings already that I can go to. There's a couple of meetings. My grandma's been going to meetings for most of her life. She will definitely be going to meetings with me. And even if she doesn't, I'll be going to meetings on my own because I think I do need more sober friends and to take those steps. I never really took the steps seriously until, I woke up in jail and kind of broke one of the things that I never really thought I would be able to do. And now I've been in here for almost 2 months, and I'm just trying to keep a positive mindset and know that as long as I can be happy, I can be happy on the outside if I just take a note of what I have to be grateful for.
All right, here's what the court's going to do. The court's going to, on the 22-379 matter, order 30 days jail to be served. Credit for the 30 days. Consecutive with the 25-1102 matter. On the 25-1102 matter, the court's going to order 45 days jail.
Yeah.
45 days on the alcohol tether. Credit for credit for 15 days. I'm already giving your client credit for 30 days.
Okay.
He's also, I believe, in custody on his felony matter, so I'm not giving him full credit for his status for all the days. So then, sir, you will have an additional 30 days to serve and then 45 days on the alcohol tether.
Okay. Alrighty.
And who's Mr. Sawicki, sir?
He was my friend and an employer.
All right, because the bond is in his name, and I'm
Correct.
pretty
He
certain
was at
he's
the last
probably
hearing.
I'm sorry, what's that?
He was at the last hearing when we admitted to giving that to the court for as towards fines and costs. He was with me on that last hearing. The blonde man.
Did he sign something indicating he would sign that over for fines and costs?
I brought it up. You never mentioned anything with it. So I don't know if he did or not, but we admitted on the stand that we were going to push everything to be pushed towards my fines and costs.
Okay, well, there's a document he has to sign. That's why I was asking if he signed that.
Okay.
Oh, no, in fact,
Not
well,
entirely
he
sure.
signed he signed twice. He does want it and then he does not want it. He signed both of them. So we'll just have to contact him to see what he wants to do.
Okay.
So the court's going to order a $300 fine, $200 cost. I'm making assessment fee of $75, justice system assessment fee of $50. That's total of $625 on the 251102. I don't know what some of the other fines and costs are on your other matter. You still owe $1,975 on this, on your 22 matter as well. So, sir, upon your release, you have to contact the court here to set up a payment plan on your balance.
Yes,
Whatever that
ma'am.
may be. Good luck to you, sir.
Thank you very much, Sheriff.
So
Go on the record.
May I ask you a question?
Okay, let's go off the record. Yes.
So it's a total of 30 days that I have to serve here and then 45 days on tether?
Yes.
Okay. All right. Thank you.
You're welcome.
Thank you. Appreciate it.
You're welcome. On the record of the matter of the city of Wyandotte versus Diego Sanchez, 251235 ABC.
Step up, sir. Your Honor, good morning. Richard T. Serrano, P33828, appearing on behalf of my client, appears to my right. Please state your name for the record, sir.
Diego Sanchez.
Yeah.
Diego Sanchez.
Thank you. And good morning. And today is the date scheduled for the arraignment pretrial in this matter, and counsel asks the arraignment.
Your Honor, I've advised my client of the nature of the charges. He understands them. He understands all of his divisive rights. And thereby we waive formal reading today of the charge as for plea not guilty for arraignment purposes.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment as to the pretrial.
Your Honor, after speaking to the prosecutor, my client wishes to avail himself of the offer. He will plead guilty to having no officer's license in his possession. And then that the amended count of no officer's license in possession, he will also plead responsible to a minor in possession. And if that's accepted, the other charge of defective equipment will be dismissed on the prosecutor's motion, as well as the original driving license suspended. He's been advised of his rights to right to the court's examination.
All right, sir, please raise your right hand. You solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay, and you heard the plea that your attorney placed on the record, correct?
Yes.
As to the amended charge of no operator's license on person, how do you plead? I can't hear you. As to the amended charge of minor in possession, how do you plead, responsible or not responsible?
Responsible.
You've gone over your advisive rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes, ma'am.
You also understand by entering into plea and be waiving some of those rights.
Yes, ma'am.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
And knowing all of that, you want to continue with your plea.
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
All right. And any immigration issues?
No, ma'am.
All right, counsel, if you can please report to your client.
Thank honor about August 24th, 2025, approximately 1:23 a.m. Were you operating a motor vehicle in the city of Wyandotte?
Yes, sir.
You had a passenger, your mother, correct?
Yes, sir.
You were the driver.
Yes, sir.
At some time, you came in contact with the Wyandotte police. Is that correct?
Yes, sir.
Found the police officer asking you to produce a valid Michigan operating license. Were you able to do that?
No, sir.
Is it because your license was not valid on that date?
No, sir.
Okay, so you had a suspended license on that date, correct?
No, sir. I didn't know. I wasn't suspended.
I can't hear or understand a thing you're saying, sir.
Did you have a valid?
Excuse me, counsel.
Go ahead.
You need to stay loud, sir, because we have to be able to record all of the proceedings, and I have to be able to hear what you're saying.
Yes, ma'am.
So please keep up your volume.
Did you have an invalid license to give to the police officer on that date? With your license not valid, is that correct?
Yes, sir.
All right. And then also, did you also have in your pocket a can of alcoholic beverages?
Yes, sir.
I'm satisfied as to both matters.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charges and dismiss the original charges per the plea agreement as to sentencing counsel.
Your Honor, my client is Floyd gainfully fight. He works at Cope Hall presently as a union carpenter. He's single. He's not on probation or parole. He's been working on trying to get his valid license back. He understands he can't drive without a valid license. And Your Honor, we would hope the court would consider fines and costs in this matter, giving him time to pay those fines and costs, but we leave in the court's discretion.
All right. And sir, why is your license not valid?
I mean, I have to take my road test. So
You've never had a license.
No.
All right. And so how'd you get to court today?
a live. Live.
Okay. And so how much did that cost you?
Like $8. I live not too far.
Okay. Interesting. Lyft appears to be cheaper today.
Live it gives you some reason.
Great. Let me see your receipt.
You don't have a vehicle in the parking lot, do you, sir?
No, sir.
Okay.
Actually, I don't got the receipt. I got it called for me. I didn't call them. And
No?
no,
And who called for you, sir?
my father.
And so you don't have any notifications that it was coming close or your driver is close or anything, sir?
No, ma'am.
Okay. You have communication from your dad telling you the ride is close?
Yes, he called me. He's at work right now. He called me one.
He called you.
Yes.
All right. Let me see your pockets, sir. Empty your pockets. Do you have any? No. I mean, don't come all the way up. Empty your pockets, please. You don't have any keys in your pockets?
Small phone.
How do you get back and forth to work down at Cobalt Hall, sir?
I usually get picked up from a coworker.
All right, sir. If you want to get your license, stop driving. Take your road test. Stop putting it off.
Yes, ma'am.
As to no ops, the court's going to order a $200 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50. Total of $525. And the minor in possession, I believe, is $100. Is that correct, Yali?
That's my understanding, Your Honor.
Yes.
Okay. So a total of $625. How much are you able to pay today, sir?
I can't pay none today. I'm waiting for my check, ma'am. If we can make arrangements.
Sir, it's been 3 months since you received the citation.
Yes,
You
ma'am.
don't have anything set aside.
Not at this current moment. No.
How much can you pay per month, Your Honor? Sir?
200.
So you haven't saved anything to bring up today, and now you are telling this court you can do $200 per month.
Yes, ma'am.
Okay. When's your first payment, sir?
Could we do it for a couple weeks from now, 3 weeks from now?
We can do December 12th. There's no talking in court. December 12th. That's a Friday, 3 weeks from Friday. And in fact, you can stop at the window to get information about how to pay online, sir, so you don't have to worry about getting a ride here.
Yes.
Don't drive, sir. Okay. And don't drink any alcohol until you're 21.
Yes, ma'am.
Same with the weed. You don't get any of that either until you're 21. Have a good day.
Thank you, Your Honor.
Okay, so let's go on the record in the matter of the city of Wyandotte versus Philip Lubacani, 2515180, 251545.
Very honored, Neil DeBoy here on behalf of Philip Lubacani. If I'm pronouncing that correctly, Mr. Lubacani, can you hear us? Please unmute and state your name.
Hit unmute, sir.
Can you guys hear me?
You can. Your name, please, for the record.
Philip Lubacani.
You and counsel today's the date scheduled for pretrial in these matters.
Yes, sir. I've been an opportunity to discuss this with Mr. Lubacani, as well as with the city attorney. Mr. Lubacani, I'll get a point for the board. We have two matters up here, 251518 and 251548. My client's prepared to plead guilty as charged with respect to 2518 as a part of a global agreement. Case 1548 would be nully prosecuted dismissed.
Okay, let me just clarify. Yes, 251518 is what your client's pleading guilty to. And then the 251545 is the one that's being dismissed, correct?
That's my, yeah.
Okay. So, sir, Gavin, please raise your right hand. You solemnly swear from testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Okay, and you heard the plea that was placed on the record, correct, sir?
Yes, Your Honor.
As to the charge of possession of drug paraphernalia on from October 24th, how do you plead?
Guilty on one of the charges, Your Honor, and guilty.
Okay. And you've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights.
Yes, Your Honor.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
And knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea today?
No, but no, Your Honor.
Okay. Do you feel coerced to enter into a plea, sir?
No, Your Honor.
Okay. Any immigration issues?
No, Your Honor.
Also, if you can please ready your client.
Say what again?
Well,
Oh.
I have some questions for you, Mr. Lubacani.
Yes, Your Honor. Yes, Judge.
Do you
This
do
attorney.
you recall being in the city of Wyandotte on or around the 24th of October this year, last month?
Yes.
Okay, and there's a police report that alleges the police found you on some private property asleep. And when they confronted you, you indicated that you had a burnt glass pipe, which is a device normally used for consuming illegal drugs. You admit that?
Yes.
You were unsatisfied with that.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And counsel,
Your Honor, I'm somewhat at a loss here, not for words, but exactly which direction. I would suggest that is the 2 weeks that he's done in jail for this minor offense, more than adequate punishment. But in discussing this matter with Mr. Lubacani, he is a fellow who has a multitude of problems and is destitute, basically. He has asked me to advise you that he has some family that's going to step up for him. His brother, Emilio, who lives in Westland, he's given me an address and a phone number for his brother, Emilio. He would be staying there. And when I discussed with him, I could ask the court to for example, order nothing, the penalty has already been served. 2 weeks is sufficient penalty, which I could ask the judge to do that. He was basically asking to be put on probation. He thinks that this will be a source for some help for him. I said, well, the difficulties with that, you can't be put on a tether because you don't have a legitimate address per se. So that isn't realistic. So again, I guess I kind of bring this back to you, Judge. What do you feel? I think all things being equal, 2 weeks in jail for this offense. And for the record, this man was arrested on the 24th of October. Wasn't hurting anybody, certainly himself. They arrested him rather than, I think he needs medical or mental treatment, frankly. He was taken to jail, he was released, and then they saw him walking down the street 8 days later wearing the same clothes, and they arrested him again for the same thing. So that's why there's 2 charges.
Well,
that's just a little editorializing.
right? But
And-
perhaps you shouldn't have the illegal paraphernalia on him either.
There's a lot of things he shouldn't be. One of them is I don't think he should be in jail any longer. But
Oh, that was pretty quick, Mr. DuBois.
well, it's still early. Your Honor. Thank you.
You're welcome. So, Mr. Lubacani,
Yes, Your Honor.
how long have you been in the state of Michigan?
Probably less than 2 years. I just moved out here with my brothers-in-law.
Well, you say just. If you've been here 2 years, it's not just. It's been a bit. And so your brothers-in-law live in Westland.
Yes, Your Honor. South
And
Illinois. They
They
live on.
Okay, how many brothers-in-law do you have?
I have one living in Westland, one living in close to Mount Pleasant, and then I got another brother that lives with my middle brother in Mount Pleasant, and then I got 2 other brothers that moved from the Philippines.
Does the brother who lives in Westland know that you want to come live with him?
Yes, I talked to him last night. He was hoping that the judge could order release me today. I will be able to stay with him for the time being when I'm on probation, if I could be on probation. Hopefully I could finish probation. While I'm on probation, I would like to find a way to start working some type of way. Because when I was with my older brother, I was working under the table. My brother's friend had a job cleaning windows, and he was helping me out with under the table jobs and so forth. My brother could say the same thing, that he was trying to get work, trying to get his SSI and so forth. So I would like to try to find a way to be successful and never come back to jail ever again.
All right. So, sir, here's what I'm going to do. I'm not showing any criminal history for your client, counsel, but I don't know what that is in California. I don't have all that information. So, sir, I'm going to order 14 days jail. Let me see here. You've been in custody since November 4th. So 16 days jail. Okay, 16 days jail. Credit for 16. Suspend fines and costs. Stay in Wesleyan with your brother-in-law.
Yes.
All right, good luck to you, sir.
So will I be getting released today or?
Unless there's some other reason, and the court's going to also, on the 251545, I've already dismissed that. Okay. All right, have a good day.
Thank you.
Thank you.
So will I be serving time 16 days in jail or will I get released today?
You should be getting released today, sir, unless there's something else that you have that's going on.
Okay, all right, thank you.
You're
So-
welcome.
I'll call my brother so he can come pick me up and so forth. Thank you.
You're welcome.
Your Honor. God bless you.
Have a good day.
You as well. Thank you.
You're welcome. All right, let's go on the record in the matter of the City of Wyandotte versus Tyrone McFarland, 251228, 251025.
Good morning, Your Honor. Catherine Kuzmiak, the 85417 for the people of Wyandotte.
Your Honor, good afternoon. Richard T. Serrano, P 33828. Your Honor, today I appear on behalf of Mr. McFarland, who appears on screen, presently housed in the jail.
All right, Mr. McFarland, your name for the record, please.
Tyrone McFarland.
Okay. And counsel?
Yes, Your Honor. It is the people's motion today to move to dismiss the charges of trespass, fraudulent schemes, and disorderly person for the defendant. The defendant has successfully been probated on a petition for mental health with the Wayne County Probate Court, and he is now under the jurisdiction of the Wayne County Probate Court.
Okay. And the court will note for the record, for procedural purposes, that Mr. McFarland was evaluated by the Center for Forensic Psychiatry on a request for competency and was found to be incompetent. As a result of that, the prosecutor filed an action or started the process and the procedure for filing an action with the Third Circuit Court Probate Court per the statute. It appears as though because Mr. McFarland is housed in the Wayne County Jail, the Wayne County Jail psychiatrist filed that petition with the Third Circuit Court, and the determination was that Mr. McFarland is currently under the jurisdiction of the Third Circuit Court Probate Court. I don't know where those. What? No, the orders from the probate court.
Could be another file.
Oh, there it is. Thank you. And it has been determined that by clear and convincing evidence that Mr. McFarland is a person requiring treatment because the individual has a mental illness. And as a result of that mental illness can reasonably be expected within the near future to intentionally or unintentionally seriously physically injure self or others. And he has engaged in an act or acts or made significant threats that are substantially supportive of this expectation. And therefore, by Judge Braxton of the Third Circuit Court Probate Division, it has been found that there is available treatment program that claims it's an alternative to hospitalization or that follows an initial period of hospitalization adequate to meet Mr. McFarland's treatment needs. Indicating that the state hospital system, Veterans Administration Hospital, or private hospital can provide treatment. Therefore, it's been ordered by Judge Braxton that the individual shall undergo a program of combined hospitalization and assisted outpatient treatment for up to 180 days. The individual may be hospitalized for up to 60 days of the 180-day assisted outpatient treatment period.
What hospital, Judge?
Well, sir, I'm not sure which hospital that you'll be at, but you absolutely need to be
What hospitals
hospitalized
are available?
because the
What
court will
hospitals are
also
available? What
Just one
hospitals are
moment.
available? What
just one
hospitals are
moment,
available?
sir. Mr. McFarland, hold on. The court will also note that upon review of Mr. McFarland's history, that Mr. McFarland has psychiatric issues dating back to 1981 in the state of Illinois. For whatever reason, he has not been consistently hospitalized for treatment or otherwise. So
True.
therefore, this court does not have any jurisdiction any longer because Mr. McFarland is now under the jurisdiction of the Third Circuit Court Probate Division. I certainly hope, sir, that you are hospitalized and you're receiving treatment. And so the
That's
court's
good.
going to dismiss this matter based upon defendant's lack of competency and his jurisdiction under the Third Circuit Court Probate Division at this point.
What hospitals are
Thank you, Your Honor.
available?
We understand that. We agree with it. My
Yeah.
client, I've discussed it with my client. Obviously, he wants the treatment that he also.
What hospitals are
desires.
available? What
And Your
hospitals
Honor,
are
we invite
available?
and thank the
What
prosecutor's office
hospitals
for
are
their follow.
available? What
Sir, I'm
hospitals are
not sure.
available?
Sir, I don't know what hospital you're going to be going to.
What hospitals are available?
She don't know. She don't.
I don't
You
know.
don't know what
Lane
hospital
County-
going to? What hospitals are available? Ann Arbor? Ypsilanti?
She don't know.
I don't know which ones are available, sir. That's something that the Third Circuit
Is it
Court
gonna be?
ordered
Is
you
it gonna be
to.
a? Is it gonna be a hospital, or is it gonna be a treat like East Jefferson? Is it gonna be Lily Bridge again? Because I'm not going to Lily Bridge. Is it gonna be?
I'm not sure.
Is it gonna be? Is it gonna be? Is it gonna be an indoor? Is it gonna be a hospital, or is it gonna be a building?
Sir, you have now been put under the jurisdiction of the Third Circuit Court Probate Division. I am not the
Which
one to
means
send
what?
you to. Please
Which
stop
means
talking.
what? What do
Please
I
stop
still have
talking.
freedom of movement? Do I still have freedom of movement?
Sir,
Do I
the
still have
probate
freedom of
court
movement?
will determine which hospital you go to. This court does not do that.
Do I still have freedom of movement?
I don't know.
That's right. I love you, baby. Be that bitch.
Okay, well, you're all set, Mr. McFarland. Good luck to you.
I'm take care.
Thank you.
So in front of what they gonna do? She dismissing your case.
On the record, the matter of the City of Wyandotte versus Lawrence Buckner, 251144. Where's Mr. Buckner? Mr. Buckner?
You can call Mr. Buckner, his name is call the sheriff. You put the up there holding and you can get it going.
Okay, and counsel?
Morning, Your Honor. Good afternoon, Your Honor. Ron John Gold, 0758 on behalf of Buckner.
Good morning, Judge. This is Judge Lawrence of the Family Buckner. I already apologize to you for earlier on my phone. It was not intentional.
Okay, all right, thank you. All right, and good afternoon, and I do apologize for the wait today. Mr. Gopal has been moving as quickly as he can. Do you need to sit down, sir?
I didn't do my hair. That seems
What's that?
it's even mine for my breaths. Okay.
Okay, you can sit down. Would you like to sit down?
Would you like to sit down, Mr. Buckner?
Okay. Are you okay? Okay. All right. And okay, Mr. Buckner's already been arraigned, and that was on October 29th. And today's the date scheduled for the adjourned pretrial. And counsel?
That's correct, Your Honor. Mr. Buckner and I have had an opportunity to review the police reports. I also obtained to the discovery the digital discovery. I reviewed that as well. Also spoken to the prosecuting attorney, explaining what I observed on the videos, as well as going through the police reports. And it's my understanding that in return for a plea of responsible to careless driving, the charge of reckless driving would be dismissed. I've explained this to Mr. Buckner. He wishes to avail himself of this opportunity. He does understand his constitutional rights, understands he would be waiving certain rights by entering into this bill. Is that correct, Mr. Buckner? Yes.
Okay, Mr. Buckner, do you need a few minutes? Are you sure? I can't hear you. Okay. Well, so here's what I just want to make sure. All right, number one, I want to make sure you're okay. Number two, I don't want you to have to utilize your breath since you don't have your inhaler unnecessarily, and we need you to speak up quite a bit so we can get you on the recording. So I just want to make sure you're okay.
It's me.
All right, are you catching him, Allie?
Yeah.
Okay, perfect. Okay. Miss, is there something we can do to help you with your breathing? Okay. All right. Please raise your right hand. Do you solemnly swear from testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And you heard the plea that was placed on the record, correct? Okay, you may lower your hand. And as to the amended charge of careless driving, how do you plead? Responsible or not responsible? And you understand your rights that you've gone over with your attorney, correct? And knowing all of those rights that you'd be waiving, you want to continue with your plea.
Yes.
You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
Knowing all that, do you want to continue with your plea? Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues?
No. Not that.
Okay. All right. The court will accept your plea as knowing and voluntary, dismiss the original charge per the plea agreement, and that's $200. Can you pay that by January 31st?
Yes, ma'am.
All right. Okay. So, sir, you're all set. If you need to sit there for a few minutes to catch your breath, that's fine. If you need some medical assistance, we can contact somebody, whatever you need, okay?
We get some water.
Some water? Okay. Thank you. I have bottles of water in my chambers. Can you grab one for him, please?
Thank you, Joe.
You're welcome.
Thank you.
If you'd like to get the when you do leave, sir, when you'd like to stop at the window and get the online payment information, then you can certainly do that as well. Okay. You can still sit there, sir. That's fine. If you need to stay there, you can stay there. And he's coming right out with the water. Okay, thank you. All right, so just take your time, okay, Mr. Buckner? All right, let's go on the record in the matter of the city of Wyandotte versus Caitlin Poquette, 25955.
Good afternoon, Your Honor. Your Honor, John Goldthorpe, plea 30758 on behalf of Ms. Poquette. Ms. Poquette.
Okay, thank you. Today is the date scheduled for the pretrial in this matter. And counsel?
I've had an opportunity to speak with Ms. Clark. I've also had an opportunity with Discovery to review the digital discovery as well as the paper discovery, and I shared those documents with her. I've had some discussions with the prosecuting attorney, and I've had some discussions with Ms. Poquette. It's my understanding that she will be pleading as charged to possession of drug paraphernalia, and this is to be taken under 771.1 if eligible. And my review indicates that she is eligible under circumstances.
Okay.
I've discussed with her constitutional rights. She understands those rights and understands that by entering into this plea agreement, she would be waiving some of those rights. With that said, Your Honor, she wishes to avail herself of this plea opportunity. Is that correct?
Yes.
I can't hear you.
Yes.
All right, please raise your right hand. Do you solemnly swear affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Charlie.
I pick her up, Allie. Please repeat that.
I'm sorry.
You need to be much louder right into the microphone, please.
I'm sorry.
So, do you solemnly swear affirm the testimony about to give in this matter be the truth, the whole truth, or nothing but the truth?
Yes, Your Honor.
That's it. Okay, very good. Okay, and so, ma'am, you heard the plea that was placed on the record, correct?
Yes.
As to the charge, how do you plead?
Yes.
Okay, ma'am, I'm not going to repeat this again. We have, first of all, when I'm talking, you can't talk as well. Only one can be recorded at a time. You may, ma'am, have a softer voice, but that means speak directly into the microphone, okay? Because we have to be able to record you. Okay, have a good day, Mr. Buckner. And, okay, as to the charge of possession of drug paraphernalia, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
Knowing all of that, do you want to continue with your plea? I'm sorry?
Yes, I agree.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please body your client.
Thank you. Back on July 1st of 2025, did you come in contact with the Wyandotte Police Department?
Yes, I did.
And during
Now,
that,
you have to keep your volume up. Okay, so please, I know you may want to try to look at Mr. Gopa, but if you are, then when you respond, you have to be right into the microphone, okay?
and during that contact, you have a gentleman in the vehicle by the name of Mr. Carlton. Is that correct?
Yeah.
And Mr. Carlton was being detained on some outstanding warrants. Is that correct?
Yes.
And the police asked you to get out of the car. You did so, and they asked if they could search you and your vehicle. Is that correct?
Yes.
And you consented. Is that correct?
Yes.
And they found nothing on you, did they?
No, they didn't.
While they were searching your vehicle, they found a purse. Is that correct?
Yes.
And inside the purse was another type of carrying bag. And in that bag, they found some drug paraphernalia, including a pipe. Is that correct?
Yes.
And that was in your purse. Is that right?
Yes.
And you had taken that other bag and put that into your purse. Is that correct?
Yes.
Defense satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge. And I'm sorry, ma'am, you do understand what the 771.1 status is, correct?
Yes, Sean.
Okay. All right. The court is going to order bond and conditions are continued. You're going to go over to probation. You're going to receive your next steps. Okay?
You
All right. Good luck to you, ma'am. And I apologize for your delay today here this morning. Let's go on the record in the matter of the city of Wyandotte versus Gerald Woods, 251248A and B.
Ready, Your Honor. Good afternoon, Your Honor. Neil Lubacani on behalf of Gerald Woods. You step up, sir, station name.
Gerald Allen Woods.
Okay, and good afternoon, and I do appreciate your patience today. And counsel, today is the date scheduled for the arraignment and pretrial in these matters. And that's the arraignment.
With waives formal reading stands mute for the charge.
For away the formal reading, enter a plea of not guilty for purpose of the arraignment as the pretrial.
After the pretrial, my client bears responsibility for the charge A, which is possession of dangerous weapon. The count B, which is civil infraction. That
Okay. Sir, please raise your right hand. You solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay. And you've gone over your advice of rights with your attorney, correct?
Yes.
And you heard the plea that was placed on the record.
Yes.
As to the charge of possession of dangerous weapon, how do you plead?
Guilty.
You've gone over your advice of rights and you understand by entering into this plea that you'll be waiving some of those rights.
Yes.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
Knowing all of that, do you want to continue
Yes.
with your plea? Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea?
No.
Any immigration issue?
No.
And counsel, if you can please pardon your client.
Yes, well, Mr. Woods, you recall being in the city of Wyandotte on or about the 21st of August of this year?
Yes, I do.
And you were in the vicinity of Eureka and 16th Street, is that true?
Yes.
And at that time, you had an interaction with the Wyandotte police officer, is that true?
Yes.
And during that interaction, the officer alleges that you had in your possession on your belt and a sheath a knife,
Yes.
and that knife apparently has a blade of approximately 7.5 inches. That's approximately correct.
Yes.
And you were unaware, apparently, that the ordinance, or you acknowledge that the ordinance in Wyandotte states that anything in a blade in excess of 3 inches constitutes a dangerous weapon. You understand that's what the
I didn't know.
You understand that is the ordinance, and I can see to that.
Yes.
Your Honor, I'm satisfied with that.
Okay, the court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea to count A, dismiss count B per the plea agreement. Are you asking for immediate sentencing, counsel?
Yeah, sure. Briefly, give you a few statements regarding Mr. Woods. Mr. Woods is he's a retired man. He's obviously got a few years under his belt. I don't think it's a situation where probation would have any sensible effect. I believe him. I should say that he's been carrying this knife as like part of his gear. He's been carrying this knife for like 40 years. And he doesn't live in Wyandotte. He was visiting someone. He was walking their friend's pet down the alley. Once again, illegal alley use was one of the charges. That was kind of interesting. It's been dismissed. But it fits with his explanation. He wasn't out breaking into places. He wasn't chasing somebody with a knife. It's nothing like that. He had this on his belt. He's used this knife for everything from eating Vienna sausages out of the can to deer hunting to, using it as a screwdriver. So he no longer has that. They took it from him, and he realizes that now. I think he's legitimately was unaware that it was illegal, but I don't suppose he took the time to pull out the law books and look it up and stuff. So he's accepting responsibility for that. I think fines and costs would be adequate. He's extremely unlikely to re-offend in this way. And he's not a Wyandotte resident. So LaSalle.
Okay, so you said that you carry the knife to protect your cat?
No. Yeah, I walk my cat is walking an animal at night. A cat, which is unusual, but
and if he takes out a grizzly bear, I got to be able to back him up.
I think he's being facetious, right?
I'm sorry.
I don't know that there's bear sightings around Wyandotte lately, but deer, yes, bear, no.
Well, there's Roosevelt bears.
And geese, the Canadian geese, yes. Bear, no. Okay. The court's going to order a $100 fine, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50, $325 is your total. Do you have that to pay today, sir?
Yes.
Okay. Stop at the window, please, and somebody will be with you shortly.
Can I get my K-bar back? A knife. Was I?
Well, that's something you have to take up with the police department. I don't have that issue before me today. It was taken as part of this case. Okay. So now that this case is concluded, then you can communicate with the police department regarding your item. Unless counsel, the prosecution is in agreement, then there can be an order for that. So you have to just, okay,
Thank you.
you're welcome.
I dare call this case, Mr. Boyd. Robert Thomas Boyd, 25B82557. Calling the Penn City Attorney, opposed. Township Attorney.
Morning, John.
How you doing, Mr. Boyd?
Pretty good.
Your name?
Robert Thomas Boyd.
Okay, so I'll give you a lawyer if you want one. This,
Thank you.
you believe your right to a lawyer?
Yes.
You're here for a review hearing. Please tell me you did something with the property.
Oh, yes, sir. I got a big trailer full of stuff out of there.
Did you?
Yeah. A big trailer. 6.5 feet high, 8 feet long, wide, and 8 feet long.
Did you get everything out of there?
Not everything.
No, no.
He's supposed to bring me another trailer when he dumps out.
I know, but did they take the whatever debris you put in the trailer and remove it?
The guy's taking it out there today.
Good morning, Your Honor. Caitlin Floyd, Paraphernalia, Brownstown Township.
Ah, so I said, do I dare call this case? What have they done? Go ahead.
Sure. Orders enforcement officer Rob Pierce went by the property yesterday. He advised that the dumpster was full. The garage, trailers, boat, cars, junk, and debris were still evident from the street. He did go into Township Hall and obtained a demolition permit application. However, he's never filed that, nor has he gotten a demolition permit.
Well, I don't need it, Your Honor, until I get ready to demolish it. I'm pulling everything out of that garage, the cabinets and all that stuff. So when I demolish it, it'll come down easy. So I didn't know if there was a time limit on the demolition permit. Is it? You don't know? Oh, she don't know either. He's supposed to bring me back another trailer today.
You gotta move a little quicker here.
Well, that's a lot of work.
We've been talking about this. You were issued citations quite some time ago.
Yeah.
And this citation was issued in April. This is November. How many notices did they send prior to that again? How far back does this whole issue go?
The property itself is, the ordinance violations have occurred since 2001.
Okay. So last I looked at the calendar, it's 25, right? I wish it was 2001, but it's not. Please. I don't want to have to send you to jail again.
I don't want to go. I got too much work to do on that.
I know, but you gotta move faster. Please?
Getting help would help a lot, but it's hard to do.
If I may, Your Honor, I did, last time we were here, a Good Samaritan knocked on my door and advised that they were there because they wanted to help Mr. Boyd. My understanding, she received his phone number from one of our hearings. She tried to make contact with him multiple times, left multiple voice messages, and he never returned her call. She is interested in finding help. He just needs to connect with her.
With
Her name's Adrian. She left you a couple voicemails.
she did?
She did.
She wants to help me?
She does.
She's gonna let that heavy stuff?
She has a whole bunch of people that want to help you to stay out of jail.
See,
I didn't get them.
Mr. Boyd,
I didn't get them.
listen to me. I have felt awful sending you to jail, but I have a job to do here. and I'm going to do my job. I don't know what else to tell you, sir. You gotta move. You gotta get this stuff out of there once and for all, for your safety too. All right, here's what I'm doing. I mean, I don't think she would tell the prosecutor she called if she didn't call. Probation is extended. I'm extending your probation. Probation's extended until, but this doesn't mean you have this long to do this. Do you understand?
Yes, I do.
To July 30, to July 30 of 26. No probation fees. Lisa, please give me another review hearing date sometime in early July.
I'm looking. Hang on one second.
Take your time. I'm going to set another
July 1st at 9 o'clock.
at 9 o'clock. I'm going to give you another review hearing date to come back in front of me, but I want all this stuff going. Listen to your voicemail. Call the lady if she's willing to, or your sons. I don't care who you get, sir.
If Mr. Boyd wants to
Yeah.
be in the conference room, I'd be happy to give him.
Sure. Now listen, I don't care who does it. You know, ultimately it's your responsibility, but I can't give you much more time. And I know you're going to start telling me the weather, but you should have done it when I told you to do this. Lisa, give me something the second or third week of July or January, please.
January 14th at 8:30.
That's your new review hearing date. So the other one, the July date, is to dismiss the case if you're compliant.
Okay.
This is going to be another review hearing date, January 14th. You got to get going. You got to call that guy, have him empty that, give you another dumps, whatever you got to do.
I understand. I would just like to reiterate that I think our biggest concern is still the dangerous building.
Of course it
Right.
is. It needs to be. Mr. Boyd, come on, man. You're such a likable guy, but you're killing me. You know that? You're going to make me do something again that I don't want to do. I already had to do something twice that I didn't want to do. Come on, please. Don't do this. Get this stuff, get that all taken care of by January, and we all can all go on. I'll buy you lunch. You and I and the prosecutor and the building official go out. I'll buy lunch. Take care of it, please. January 14th. Thank you. Have a good day.
Thanks.
Ricky Floyd Parker Jr., 25B1493998.
Morning, guys.
Good morning, Mr. Youngs. Give me 1 second here. Your appearance, sir, your name. All right, I need to ask, is anybody here from Granite Televalley? Anybody here from Granite Televalley? You are? Come on up here, please. You can go right to that microphone. That is a microphone. You don't have to walk in that's a microphone, believe it or not. Can you come around this? There you go. Come on up a little bit further so you're speaking into the microphone. Your name, ma'am?
Suzanne Bryant,
And what is your position with Granite Televalley?
community manager.
Okay, so you're here, appearing here to make a claim for restitution or a statement?
That's correct.
Did you file, you have a piece of paper? Do you have any out of pocket?
Caitlin has, I haven't done anything yet because of the season. We would have to do it next season. So he took down a cherry tree and a fence. And so there's an island in my community that cherry tree was in. And it's probably about 6 feet wide, if it's that wide. The bulb of the tree that he took down, most of it is still in there, and you have to have backhoe come in and dig out the thing and then replant a 15-foot cherry tree. They don't feel $2,800 to do that and replace the fence. They believe that's too much money.
Who does?
We do.
His attorney.
Well, you haven't been communicating with his attorney, have you?
No, Caitlin has.
Calling Caitlin. $2,800. How tall is the tree? Let's talk
It's
about.
about 15 foot. The root that we took out was about this big around, so the rest of it is in that ground.
You want to get alternate estimates?
I said they could plan, I don't care, as long
Might
as.
be able to go to his insurance company.
I don't know if they cover that, but
Why?
it just sounds so unusual. I hadn't really thought about it. We initially just,
What about the fence? What kind of estimates you have on the fence?
$380, it's a split rough fence, it's not an expensive fence.
the fence option was.
All
I
right.
saw 2,500 for the cherry tree.
Have you had a tree cut down lately? I've had trees cut down and they are not cheap.
No, I think they need to dig it out. It's the expensive part.
Well, I get, but you gotta have an option, not just, I think it's too much. Is Foley Carter your name?
Caitlin Foley, Carter, Rossmont Township.
So what kind of restitution? Did you talk to Mr. Youngs about the restitution?
I did, and I provided the estimate that Ms. Bryant.
Is that from a tree company?
It's from a maintenance company.
It's for the cost of both the tree and the fence.
I know the fence seems like it's minimal. It's $380 or some such. Do I have a copy of that estimate?
I don't believe so, Your
I
Honor.
doubt it, Judge.
Can I have one?
I can look.
Okay.
And Your Honor, I don't care who does it. I mean, they can hire whoever they need. I just want it restored.
No, that makes sense. I mean, you're entitled to have it restored. You're entitled to be in the same position, so you can't. All right, let me just get this estimate from her and we will go from there, okay? Did you call any tree removal companies?
I did, but, it's trimming season and they said that they could get to me at some point in time. I have a tree company coming in next week. I could get another estimate from him.
Well, this is 2,500 for the tree. That includes the tree and the fence. So I mean, you're looking somewhere at the rate of about $2,500, I guess is what they've got here.
I thought it was 2,500 and then 300 additional for the fence. Wasn't it 2,800, John? Or am I?
Yeah, but I thought you guys were talking like 2,800 for just the tree removal and then 380, I thought you said. Did I misunderstand you?
It's 25 for the tree and 380 for the.
I only see 300 here on the replace
300. I don't have it.
split rail fence.
Yeah.
All right, well, let's do this. I'll set a restitution hearing. You guys can make a claim with your insurance company. You can coordinate with the prosecutor. You can send out somebody to get an estimate on that. You want them to grind out the stump too, right?
Yeah, everything's got to be removed.
I mean, that's a job too. It's just not surprising.
The look at the estimate, you just say, oh, a cherry tree. And I started Googling cherry trees and they're not even $500. So it's a little bit of just, we need to.
I've had trees cut down and I'm telling you.
Well, it's what I'm saying, removal of a whole tree. We didn't realize that was part of the game. Or at least maybe.
What do you want them to, you just want them to replace it or you want them to remove and replace it?
I want them to remove because I want it in the exact same spot. That's the only place it can go. So that rest of that root has to come out in order to plant a tree.
You'll be lucky to get away with $2,500 to remove that put in a similar tree. All right, let's go on with the sentence. I'm going to listen to whatever else you have to say. I'm going to set this for a restitution hearing. We will talk about when that is going to be at the conclusion of the sentence. That will give people an opportunity to do their research, okay? So, have you had a chance to review the report with your client? Is that okay? Or
Yes.
do you want to say anything else before you sit down?
No.
Do you want to say anything?
I did complete a victim impact statement that should be in the file and attached to the estimate.
Okay. Let me just, yeah, I see that. Okay. Good enough. Anything you'd like to say? Is everything in this report accurate? If you want to say something else, you can. If you don't, you can have a seat and we'll give you a restitution hearing date here.
Yeah.
Everything in the report accurate?
Yes, Judge.
Anything you'd like to say on his behalf?
Just that he's been very proactive. He wants to get going probation, even with respect to this restitution issue. He said, I hope we would at least get going on the probationary requirements so I can get him moving and, hopefully we're out of the way. So looking forward to playing Colin doing whatever this court asks him to do regarding the conviction. That's all I have, Judge. Thank you.
Sir, is there anything you would like to say?
I apologize for my actions and I suffer the consequences to ground. And
Do you have his AA verification?
yes, sir.
You can just show it to your lawyer. Has he been going at least twice a week since October the 8th?
Yes, sure looks like it, Judge.
Okay, so he's got at least 10 or 12 on there. Okay. Oh, okay.
He was gone before we go to rain, but I just glanced at it and I see 11-8, 11-9, 11-10, 11-12. So it's the frequency seems to match up with what we've asked for.
So I don't think I have to tell you how outrageous this was, right? I mean, you drove off the road, you ran into a fence, you ran into a tree, you had way too much. You had 3.5 times the legal limit. 18 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs, and ETGs bi-weekly for 6 months. If you're clean, I'll then revert it to monthly. You're to remain on the SoberLink device until February 15th of 26. So we're going to set a restitution hearing. You are to pay, defendant to pay restitution after hearing as determined by the court. We'll give you that restitution hearing. We'll talk about the date on that as well. You're not to enter Granatella Valley Mobile Home Park. You're not to enter there at all. AANA 3 times a week until an intensive outpatient. You're going to go to intensive outpatient. Once you get into intensive outpatient, you can stop going to AA. You're also going to attend the victim's impact payment. I believe I've covered everything except the court work program, and I have to have you do 6 days jail credit 1, serve 5. I'll let you serve those on the court work program. 5 days court work program. There's $175 a day, $175 charge for that It's 35 a day, 300 fines, 250 costs, 75 victim's rights fee, $50 justice assessment. So fines and costs here amount to $675. You have a screening fee of $60 for $735. You have cost of recovery of $225 for a total of $960. Probation fees are $360 for a total of $1320 plus your court work program fees. Everything included amounts to $1495. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I don't know how to put this to you, but you got to be careful. This is crazy. Okay?
Understood.
You may be eligible for early discharge from probation if you're compliant after half the time. This could have been worse. We're setting a restitution hearing. How long will it take everybody to get their figures in order? Why don't we just set it, Lisa, after the first of the year, and that'll give you a chance to save some money.
Sounds great. I was gonna say 12/17 is, but I was just looking at my calendar. If you wanna,
We'll do it after the first.
okay.
Unless you have a problem with that. Let's go to like this, my first or second docket, like the second week of January with Brown Sound.
January 14th at 9 o'clock.
January 14th at 9 a.m. Okay?
Take him down to
Probation. Can he pay all this today?
I asked him if he could pay 200 today. Are you able to pay? Can pay 300.
You get paid weekly, right?
I get paid bi-weekly.
Bi-weekly? How much can you pay bi-weekly then? No, how much can you pay bi-weekly?
About 125.
I'll make it 100. When do you get paid next?
2 weeks from today.
Okay.
Anytime. No, 2 weeks. The check comes in usually Wednesday, Thursday.
All right, let's do this. You pay $300 today. You pay $100 bi-weekly. And I will start that beginning on December the 8th. If you need more time, what you have to do is call the court. If you don't have the money before the due date, I'll be glad to give you an extension. Just don't be fearful or nervous, because I don't care how many times we have to do that. What I'm not going to be nice about is if you don't call the court and if you don't call the court and get permission to get an extension. And again, I don't care how many times we have to do that. Actually, I'm only going to have you pay $100 on the impaired charge today, because I'm going to have you pay the fines and costs on the B file, $200. Okay. So you'll pay that one today, the civil infraction of refused PDT, and then $100 down on the impaired, and then $100 bi-weekly starting December 8th. Anything else?
Cashier first on probation?
Yes, sir. Thank you. Have a good day. Good luck, sir. Thanks a lot, Ms. Bryan, wherever you are. Naya Lene Thomas, 25B1489438A.
Morning, Your Honor.
Good morning. How you doing, Mr. Granata?
Good. Peter Granado, representing Ms. Thomas. This is the time and date set for the sentencing hearing.
Your name, ma'am?
Nine Thomas.
All right. Have you had a chance to review the report with her? Are there any material additions, corrections, or deletions?
I know you're okay. But we would like to speak to a couple of items on the report.
Okay. What would you like to say?
First, we would like to, on number 4 in the recommendation, it says that she shall not frequent any place that serves alcohol. Ms. Thomas is a bartender part-time, and we would like the court's understanding that she can continue to work as long as she doesn't frequent that establishment or any other establishment outside of work hours.
Okay.
The second thing is that because she lives about 30 miles from court, we would ask the court to, instead of a work program, if you would consider doing a community service.
Is this called Night Owl Bite Club? Did they spell this correctly on here?
It's Night Owl. I don't know what it looks like.
Night Owl, NITE? Yes?
Yes.
I heard everything you said. I'm not sure I can go along with it. Anything else?
No, well, other than the fact that Your Honor, she's only working part-time, and so therefore, and she's obviously qualified for indigent counsel, so she has very limited income. And so the fines, that would be assessed and the cost for her probation are going to be possibly more than she can afford.
You got a bachelor's degree from Florida A&M. Why are you working in a bar as a bartender and then going out? This is crazy. This scares me. Does it scare you? You have a 311 on the breathalyzer, young lady. You're far too smart to be doing this. Right?
Yes.
Do you know how high that is? I mean, I guess now since COVID, everything's high. I don't know what in the world's going on out there, but it scares me that you're still working in a bar. And it bothers me that you are living with your parents, and that's good. I guess you got a son. Is the father in the son's life?
No.
Like child support from him?
Trying to, but the case is kind of going on and it should be.
Where does he work?
I believe he just got out of jail last month.
Nice. Now, what's a smart girl like you doing with somebody like that? I mean it. I want to have a conversation. Why are you allowing someone who goes to prison to father your child?
I think like when we got together, like we were in high school, so he was kind of young and he's still young minded. So I mean, people change once.
Okay. Well, what did he go to prison for, out of curiosity?
What are you going to
Prison for?
That I'm not. I believe it was something he did at school. Like he was in school and then he violated his probation at
I don't go to prison. If you mean prison, you mean prison. You said prison, didn't you? I thought you said prison. Okay. You've been going to AA. Let me see your AA attendance.
Yes, sir. She's gone,
She's been gone 4 times since November 5th, so at least 6 times. 5 times? Fair enough. I trust you, Mr. Granada. Take that back. You on the sober link? You blowing into that? You have any positive blows?
They haven't called me and I don't know if I've had to drink since.
Okay, so because I mean, to me, you seem like a really nice lady, and you're not acting like it. You're just not acting like it. I mean, you've got an attempt check, no account. You pled guilty to back in April. Retail fraud, you pled guilty to back in April. You got a bench warrant in Pennsylvania for shoplifting. Got to reevaluate.
Yes. I called.
I'm shocked that you weren't vomiting long before you got to a 3-1. The overwhelming majority of us would be vomiting well before we got to a 3-1. I'm not trying to make you feel bad. I'm trying to make you reevaluate where you're going with your life. You can continue on this path, and it's not going to be a happy life for you. It's just not. If you continue on this little excursion that you got going here. Am I making sense or not? Am I just an old man that you just don't, he doesn't understand?
No, you're making sense. I just feel like, well, the Pennsylvania charge, I was taking care of that.
I don't want you to talk about that because you're still not convicted, and I don't want you to say anything against your interests, so.
And the conviction from April, the conviction from April was something back in 2020. So I was just recently out of high school and that was something.
Why'd you wait until 25 to take care of it? You didn't show up in court?
I had moved to Florida, so I went to school. I didn't know I was
Did
supposed
any-
to be going to court, and I had paid the warrant, and then I didn't know I was supposed to be going to court.
You
After.
got a bachelor's degree.
Yes.
I mean, come on.
I mean, that was my first time. I didn't know I was supposed to be going to court after I paid.
You get what I'm saying. I'm not trying to quarrel with you. You got a bachelor's degree and you are acting like a criminal right now. And I hate to say that because you seem like such a nice kid, to be honest with you. But you can't do this. You want to do this, it's just a ramp to unhappiness. I mean, if somebody showed me this, I would just say this person's not going to be happy unless they do a 360 pronto. That's all. Am I done talking? Do you want me to be done talking? I'm not trying to embarrass you. I'm trying to make you think because so far you're underachieving. One thing we should all try to do in our lives, in my view, was try to not underachieve, try to overachieve. Like if the best I could do was salt in the fries at the local fast food restaurant, hopefully someday I'd at least become an assistant manager. And right now, you have a lot more talent than the salt fries any place or be an assistant manager at a fast food restaurant and you're squandering it. And it's going to get harder, not easier. Are we with one another?
Yes.
Is there anything else you want to tell me?
I
Go ahead.
feel like I've just been learning like day by day, like even going to the AA meetings, it's been helping me like realize like I don't need the alcohol, and then it's just been helping me like I don't want to say progress. Well, they do say in there like go for progression, not perfection. So I do feel like I have been progressing like day by day, taking it step by step. So I don't want to say like I'm a failure, but I do feel like I am.
Well, don't feel like you're a failure. You can't go back and undo anything you've done. You can change how you're acting going forward. So that's a good thing. Right? I think that's a great thing. If you seem sincere, I believe you. Let's turn it around, okay? All right? 18 months probation. I can't go along with this 12-month stuff, not with a 3-1. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs. And by the way, I'm going to let you continue your employment at the Night Owl Club. I'd really think that you should consider other lines of work, to be honest with you.
I mean, I had the only reason why is because I had those warrants that I previously had.
I'm just telling you. When somebody has a 3-1, the last place they should be working in is a bar. I'm not going to stop you from making a living, but I'd suggest you strongly consider getting out of there and getting a regular job that's going to help you build a career. You don't strike me as the type that you were going to Florida A&M. You weren't saying, I'm going to go to Florida A&M and get a bachelor's degree so I could be a part-time bartender. I know you didn't do that, right? Okay, so let's do that. I'll let you continue the employment. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs, and ETG tests. I'm going to make that bi-weekly. I mean, I can't really do much better than that. Bi-weekly for 6 months. If you're clean, then monthly. I still want you on the SoberLink device. Defendant to remain on the SoberLink device. I know it's expensive. I hate to do it, but this is for your protection and the public's. You remain on the SoberLink device until February the 1st of 26, okay? February the 1st of 26. In terms of fines and costs and everything else, 300 fines, 250 costs, 75 victims' rights fee, $50 justice assessment. I want you to go to, well, let me cover this first. I want you to go to AA meetings again at least 3 times a week. I'll cut it down by 1 until you're in an intensive outpatient treatment program. Once you get in intensive outpatient treatment, you no longer have to attend AA or NA. So 3 times a week until an intensive outpatient treatment. Attend intensive outpatient treatment with aftercare. Attend the victim's impact panel. The court work program, I hate to make you drive 45 minutes, but I'm not letting somebody just do community service that had this high of a breathalyzer. So I'm gonna order 5 days jail credit, 1 serve 4. I'll let you serve one of those by way of community service. 1 day, 8 hours community service. You can do that at any nonprofit organization by January the 10th of 26. You're to serve 3 days on the court work program. There's a $35 a day charge for that for a total of $105. Pay fines $300, as I said, cost $250, $75 victim's rights fee, $50 justice assessment. So your fines and costs amount to $675. Screening fee is $60 for $735. Probation fees are $360 for $1,095. You have to pay $225 for cost of recovery. So your total there amounts to $1,320. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I'll be happy to set you up on a payment plan. You can tell me how much you can afford to pay weekly or bi-weekly, whatever the case may be.
Judge, I got a different total.
Okay, thank you. What do you have?
1425.
You know why? I must not have added in the court work program fees. Thank you very much. 1425. Yes, that's exactly what I did. I didn't add those in. So 1425. Wait a minute. 15, 675, 785, 95, 95, 1195, 1220. You know what, Lisa? I think it's 1325. Let's go over these. I got 300 fines, 250 costs, 75 victims' rights fee, $50 justice assessment. So that should be 675. The screening fee, 60 for 735. Probation fees. You're right. You're right. That's 11. You're right. 1425. You tell me how much you can pay bi-weekly or weekly, as the case may be. I'm gonna let you pay $65 bi-weekly. How's that? And we'll start that beginning on December the 8th. Is that good? If you don't have the money, you call the court. We'll come in here on or before the due date, 8:30. I'll be glad to give you an extension. I don't care how many times we have to do that. You got a kid, you got Christmas coming up. I believe you're going to do a lot better. I certainly hope so, because I know you've got it in you.
Judge, can I just add one request? Can Ms. Thomas come back after 9 months? And if
Yes.
compliant?
Yeah, if you've taken care of everything and there's been no violations in the preceding 90 days, then you can come back and petition in 9 months and you'll be discharged. Okay?
Thank you, Judge.
I wish you well. You're a nice lady. Act like it.
Just kind of confused about
What part?
so you want me to come up here once each?
No, 3 times. They're going to schedule you probably on 3 Saturdays or 3 Wednesdays. It depends. I can't in good conscience give somebody who's got a 3-1 the community service. Just can't do it. Okay? But they'll spread them out for you. You go talk to them. If you have a problem, come back and talk to me. Okay? Good luck to you. Wish you well.
Thank you, Judge.
Derek Paul Lopez Jr., 25B 149-536 A, B, and C. And then I also have, hang on 1 second, I have 25B 149-537. Good morning.
Good morning, Judge. For the record, House Counsel Attorney Mike Baldwin, P 65417. Yeah, my client, Mr. Derek Lopez, certain news, please state your full legal name. Derek Paul Lopez. Judge, thank you very much. Judge, today is the date and time set for a pretrial and opportunity to work out a resolution. My client will be pleading responsible to careless driving as well as defective equipment, which is tinted windows. As in return, the prosecutor is amenable to dismissing the 2 underlying misdemeanor charges under 36A and B.
Is that what you want to do?
Yes, yeah.
Okay, you gotta use your head here, my good man.
Judge, just for the record,
This welcome officer when ordered to stop on 2 occasions. Drove in a careless manner by driving toward oncoming traffic, the plea officer. Now listen.
Judge, I realize he hasn't pled. I've been working diligently with the family. He has a very good support.
Where are they?
And they're in here.
Who's that, your mom?
That's my mom, the one black is my sister.
And we've been working very hard on this particular file, because it's important that he understands what the allegations are, the seriousness. And we've worked out this global resolution where we think that the civil infractions will resolve this, and my client will have learned his lesson.
Well put, Mr. Baldwin. Well put. I mean, you got a good deal here. Grow up. How old are you?
Oh, I'm 19.
He's in welding school.
Grow up. Okay, please. To the charge careless driving, responsible or not responsible. To the charge defective equipment, tinted window, responsible or not responsible. Pleas are accepted. The disobey a police officer and flee and elude is dismissed. 225 on the careless, 120 on the tinted windows, 345. You have all that to pay. $345.
That's up to date, Eric? Judge, he'd like to pay that today and resolve.
You graduated, right?
He's working through his welding school. He did finish high school.
Okay.
He's gainfully employed. He's definitely working. So
good luck.
Thank you.
No more silly things like that, okay? Best of luck.
Thank you, Judge. Yeah. Judge, at the police report, I have Jonathan Johnson down in the clerk.
Jonathan Patrick Johnson. You have a question or something, ma'am?
No, waving by. He said bye.
Oh, to me or to him? To the lawyer?
Thank you.
25B148-931A and B. I'm sorry, 931, and then I have 25B148-932. So
Thank you, Judge. Judge, today is the day of time set for sentencing. We have had an opportunity to review the pre-sentence investigation report. We'd like to announce there are no deletions, corrections, errors, or omissions. Moreover, I spent just a couple minutes with my client, commending him on his election to be admitted into the sobriety court program. He's very excited. We're hoping that the court will allow him today at sentencing to be entered into the sobriety court program. I have nothing else to state. He's ready to go.
Mr. Johnson, your name?
Jonathan Johnson.
What do you have to say?
What's your onset? What is your sobriety date?
I think it's the 18th, if I'm not mistaken.
18th of November?
October.
I'm just kidding. I knew yesterday was the 18th. I was just teasing. What do you think so far?
Things are going, I guess.
I did not immobilize your vehicle though. How'd that get by me?
I'm like caretaker.
Yeah, but I gotta immobilize this vehicle. You have a 2013 Chrysler you still own, right? What do you mean, no? Yeah, what do you mean? What do you mean? I don't know what you mean.
That's out of commission.
What do you mean it's out of commission?
It's not working properly.
What does that mean?
Not drivable.
Well, what's wrong with it?
So they have to put settlement.
When did that happen?
It's there before, so I've just been trying to.
I got to order a mobilization of it. I have no choice. You had another offense here that preceded this, right?
Yeah.
I have no choice but to do that. So I'm going to have to order 90 days of mobilization to be completed within 7 days. That is by November. I'll tell you what, because of the holiday, I'm going to give you. Oh, no, I can't. I mean, next Wednesday by November 26th. Okay. So Lisa, we're going to have to do that order. That's my fault. I wish I had missed that. But I have to order that. I think you've been great so far, Mr. Johnson. You laughed, you smiled, that's good. You seem to be doing well. And I really commend you for taking these steps. You're doing the right thing. Is there anything else that you'd like to tell me?
You did have a reason for it. Oh my gosh.
I had a reason what?
I guess to use to like use the vehicle or not. But that's all it's about.
Say that again. I'm sorry.
He felt that you actually had understood that there was a reason for his need for the vehicle. What Your Honor is saying is the legislature,
I can't, they make me do things sometimes that we don't want to do necessarily. The good news is you're gonna be revoked. The bad news is you're gonna be revoked. The good news is, if you haven't been already, the good news is that in 45 days from today, you can come in here and request a restricted license. Now, you're gonna have to finish the immobilization period.
About to book the date to so on December 8th.
For who?
That's what I was getting from you all.
December 8th for what? The restricted? I know, but I gotta order a mobilization. I don't know why. I can't do it. I won't do it in here until you're accepted into the program. It's gonna be 45 days from acceptance. You might have started a bond phase. I just had this conversation with one of the probation officers. I'm sorry, I just can't do it. I can't. Okay? This is not my rule. The law, the legislature tells me I have to immobilize. 2 years probation. You cannot leave the state without the consent of the court. You're to comply with all agreements, guidelines, and requirements as indicated in the Sobriety Court Handbook. You're not to violate a law. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're to submit to chemical testing on demand of me or the probation officer. Pay all costs associated with the testing, but really, we're gonna take care of all that now with our grant. As long as you test every time and you test negative every time, we're paying for your testing. Same thing with the sober link if I order that. Submit the PBTs, ETGs, tests, and chemical testing on demand of probation. Complete 60 days on the sober link. Yeah, I gotta have you do that. That'll be on our dime now. Okay, so you have to be on sober link by end of day. Do you understand that? Do you understand?
Yeah.
You understand what I'm saying to you, sir? Okay, also you're to attend AA meetings 3 times a week and provide written proof of attendance, obtain an AA/NA sponsor, attend a substance abuse treatment program, attend the Victims Impact Panel, attend and complete the Armed Specialty Weekend Program. You have to report to Sobriety Court status review hearings with me every 2 weeks. Again, it's either 7:30 in the morning or 3:30 in the afternoon. Obtain and maintain employment with proof provided. You're doing really well on this. So I'm going to kind of go light a little bit on I think you've given me reason to be optimistic. Fines are 200. Costs $200. $75 victims' rights fee, $50 justice assessment. So that in and of itself is $5.25. You have a screening fee of $60 for $585. You then have probation fees of $480 for a total of $1,065. And then $360 in sobriety court probation fees. So those are going to bring it, I believe, to $1,425. I'm going to just tell you what, you've been doing well. Complete 6 days jail credit, 1 serve 5. I'm going to let you serve those by way of community service. 5 days community service in lieu of jail, okay? I won't make you do court work program. So that's 40 hours of community service. I'll give you all the way until February 28th to complete that. Community service to be completed by February 28th. Do you understand that? All right. All right. Do you have any questions?
They're gonna go over these things with you in the probation department.
I'm looking forward to helping you, Mr. Johnson. You have a very nice disposition. Really. Can he pay all this today or does he need time? How much do you have today?
Gotta be $2. Shirt on the back. Exactly.
Why are you only earning $200 a week? How are you surviving?
Oh, because child support, stuff like that.
We all paid what?
Definitely. And then I was kind of getting
How much do you make in your employment though? You don't get to deduct every
$20 hourly, and every 2 weeks you get paid. So
you're making 1,600 gross if you're working 40 hours, right? Can you pay $60 bi-weekly? Yes. Pay 60 bi-weekly starting December the 8th, but you gotta stick with that. If you don't have the money, you have to come talk to me, okay? You'll meet with probation. I really look forward to getting to know you. Remember, you have to get a SoberLink device by the end of the day. You also have $200 on the PBT file. Just pay this by March the 1st, 26, okay? I'm getting, somehow you're gonna have to fit that into your budget, all right? Good luck, Mr. Johnson. Have a good day. Thank you. Keep up the good attitude. I appreciate it. Shakira, Nicole Lindsay, 25B 149-577A and B. Good morning.
Good morning, and I'm pleased to sound before Joseph Humphrey on behalf of Ms. Lene, the pros and podium at this meeting.
Good morning to you, Mr. Humphrey. Ma'am, your name? For purposes of arraignment, does she stand mute, waive formal reading?
Yes, Your Honor.
So what do we got? A super drunk, we got an expired license, and then we have, that's it, right? Is that it?
Yes, Your Honor.
2 charges. And what's the prosecutor going to do? They're going to offer impaired and distracted driving. But first of all, she stands mute on all of these charges, right?
That's correct, Your Honor.
So she's going to plead to the distracted on the drive while license expired. And that drive while license expired will be dismissed, and she's going to plead to operating while impaired with the super drunk to be dismissed. True?
That's correct, Your Honor.
Is that what you want to do, ma'am?
Yes, sir.
How high was the breathalyzer or blood result?
It was 2.4, I believe. 0.24.
I get it, but it's quite high. Right?
Yeah.
All right, if you plead to impaired driving, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs of all those 4 points. License suspension, revocation in accordance with your record in your vehicle could be, or might have to be immobilized depending upon your record. That is the possible penalties on the impaired charge. I'll then dismiss. Once you plead to that charge and you plead to distracted driving, which is a civil infraction, I'm going to dismiss the super drunk, which is punishable by up to 6 months. Your lawyer did a good job on that. And the expired license, which is a 90-day misdemeanor. Do you understand that? You agree to that? And did you sign, read, and understand the advice and rights? If you plead guilty, you will be giving up all those rights, and we are not going to have a trial of any kind. You understand that? Any questions before we go on? To the charge operating while visibly impaired, how do you wish to plead? On October 26th, it looks like, 2025 at 9:05 p.m., were you operating a motor vehicle on Dixner I-75 in Brownstown Township?
Yes.
Prior to operating that motor vehicle, did you consume alcohol? And if so, what did you drink and how much?
Yes, 3 cocktails and some,
What kind of got things?
looks like mixed drinks like slushy from crab and karaoke,
How many drinks did you have?
3 of those.
And what else?
And then after I left, I had probably like some shots.
What do you mean probably like? Do you remember?
I don't remember how many.
This was only October 26th. It was
Yes.
3 weeks ago.
Not,
How many other drinks did you have and what were they?
I had probably like 4 shots and
Of what?
tequila,
What else?
2 cocktails and
What kind of cocktails?
lemon drops.
This is on top of the slushy drinks you were talking about
Yes,
before?
And I
Okay.
hadn't eaten anything.
Okay, what else did you drink?
That's it.
And was your ability to operate the motor vehicle impaired because of that alcohol consumption?
Yes.
Why were you pulled over by the police?
He said because I was driving too slow.
How fast were you go?
35,
In a,
50. I was lost.
so he pulls you over. He administers a breath test, a PBT, right? And then you're transported to the police station. Is that what happened after you were arrested?
Yes.
And did you take the intoxilizer, the breath test?
Yes.
And counsel, you stipulate that the results were 0.24 for purposes of the plea?
Yes, Your Honor.
Are you on probation or parole?
No.
Ever had another one of these?
No.
To the charge distracted driving, how do you plead?
Guilty.
Responsible?
Yes.
I'll accept your plea to operating while impaired. I'll accept your plea to the civil infraction charge of distracted driving, dismiss the super drunk, dismiss the drive while license expired, refer you for a screening and assessment. That's pretty high though, young lady. Where does your client work at?
She's a stay-at-home mom. Yeah, she had a child with special needs that she cared for, and she educates that child, and she has another child that's in high school that she also cares for as well too. And she is very remorseful, Your Honor. She does understand that this was a great mistake on her part, and I don't believe that the court will have to see her again after this.
All right, I got it. No alcohol. So I'm going to give you $1,000 personal bond. You don't have to post any money. But I do want you going to AANA in person at least 2 times a week, okay? You have to go in person. We're going to hand you a form. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. AANA twice a week. You cannot leave the state without consent or violate a law, and you must appear in court as directed. Do you understand all that, ma'am?
Yes, sir.
Mr. Humphrey, anything else?
I believe that is complete, Your Honor.
We're gonna-
Yeah, I'm sentencing date.
Yeah, we're gonna give you the sentencing date right now, and then you just double check your calendar. What do you have for me, Lisa?
December 3rd at 8:30.
Just get my phone.
Take your time.
Yeah, that's fine. We can make it.
Okay, December 3rd at 8:30. So you painted her a form, John?
Yeah.
Okay, ma'am, go down the hall, get your notice, and then go across the hall to probation, where you're gonna fill out a questionnaire and be interviewed. I have to order that, a screening and assessment. So you'll fill out a questionnaire, you'll be interviewed by probation, and then you'll come back for sentencing on that date that I gave you, December 3rd, with your lawyer. You'll have a chance to review the report and recommendation with your lawyer, and we'll go from there, okay? All right? You're welcome. Well, you're smiling. That's good. Good luck to you, Miller.
Thank you. I appreciate it.
Thank you, Your Honor.
Thank you. Nice to have you here.
Yeah, nice to see you again.
It's been a while, hasn't it?
Yes, sir.
All right. Take care.